This We the People News. Okay? Not an attorney, not giving legal advice, educational purposes only. Never look straight forward, always look around you, be able to protect yourself by any means necessary. Okay? Let's proceed forward.
Trial. What's speedy or what's reasonable in 1791 might not be speedy or reasonable in 2017. So what the courts have said with respect to speedy is there's not a bright line rule, say 1 year, 5 years, whatever it might be, that somebody has to be brought to trial after being charged. Rather, what the court does is it considers how diligently the prosecution has tried to pursue the case in light.
Now, why is it up to the prosecution how hard he works? Right? This is my right for a fast and speedy trial, not the prosecutor's rights. And the judge has no authority to work with the prosecutor of my rights. Now, furthermore, understand this as well. When you go into court, you are presumed you're waiving your right to a speedy trial. Why is the court automatically doing that when it's a right? So it should be presumed when I walk in that court, I'm going to have a speedy trial. And then I can backtrack it and say, hey, look, I'm not impaired. Let's go ahead and waive my rights of the speedy trial. Okay? 2 years is not reasonable. Okay? It's not reasonable for a plea bargain. It's not reasonable to proceed forward. It's not reasonable. Period. And that's what the average is in Texas.
Of other factors, such as the complexity of the case, whether the defendant himself wants the case to go to trial soon, or whether the defendant himself has agreed to certain delays or said that he doesn't mind them, and whether there's prejudice that has occurred, which is a legal way of saying whether somebody's been harmed or injured by the delay. Say, for example, a key witness has now died or fled the jurisdiction. So it's flexible words like speedy, in essence, translate some measure of discretion and flexibility to the courts.
Why is our legal process so much slower than it was in the 18th century?
Okay, so that connects up to the second set of rights we've constructed around what makes something a public trial. And one of the main things there is the jury right. Juries in the 18th century, we didn't have a jury selection process. The first 12 people who didn't know the plaintiff or the defendant or the victim or whoever it was would be impaneled, and they would serve all day, and they'd hear all the cases that came that day. And you didn't have lawyers involved in most of these cases. Usually it was the victim against the defendant himself or herself. No lawyer speaking for either side. That was the norm. The defendant had a right to hire a lawyer, but usually couldn't afford it and didn't. And
then think about that. Who's the man or woman making a claim? Okay, please step forward. All right, the claimant has firsthand knowledge, y'all, not that attorney. It's hearsay. Okay, and with the way today's operating in is by information. Okay, we sometimes get affidavit, but it's mostly proceeded forward with information. That's how the Russian kid killed his dad, was by information. But he didn't. By information, he was part of the government killing his dad.
There weren't rules of evidence. There weren't complicated motions. There weren't technical jury instructions. So the trials themselves took, as I said, an hour, 2 hours. Pre-trial proceedings did not involve lots of legal motions because there were no lawyers to run them. The judges themselves often didn't have legal training. There were no law schools in America. So when you have a system like that, it's not that cumbersome. There's very little incentive to bypass it. And you don't have professional lawyers who are looking to get this case done with and get on to the next case. Or who...
All right, remember when I told you the trickery word? We didn't have lawyers that wanted to get this case done and over with and proceed forward. He just explained when it was man to man, without the attorneys, it took a couple of hours. Right or wrong, You know, it was a lot less time.
Have seen enough cases that they can bargain back and forth and strike a bargain for this case that's about where the previous cases came out. So you didn't have an incentive for plea bargaining. It wasn't slow enough. You didn't have the experts who it would take to run plea bargaining, and you didn't have the lack of investment in your own case that makes plea bargaining possible, or the technical rules. So these cases actually all did go to juries, and the expectation was they all would go to juries, and the jury right wasn't just a right of a defendant. This happened in every case because the public had a right to do justice itself, as well as seeing justice done.
Oh, I have so many questions about this. So,
Right? So they're kind of backpedaling just the same as like, we're in this quandary.
for one thing, do you think our current system is an improvement on this older system of juries and not so much plea bargaining? And also, why is there so much plea bargaining today?
At the time of the founding, there were no deals to be made short of a full trial. That's a huge contrast with today, where over 90% of criminal cases in this country are not resolved by trial, but rather by what's called a plea bargain, which is a defendant coming in and saying, look, I will plead guilty to a lesser offense or to the same offense you're charging, but with a guarantee of lesser punishment, as long as you...
They're right? But they don't explain, if you make it harder on them, then your sentencing is going to be stronger. It's going to be retaliation. They don't call it that, but that's generally what it is, right? And nobody is clearly defined what the plea bargain is. It's contract law. Well, even though that we have a right to contract, the government itself is not supposed to involve themselves in contract with the people. Okay? They're supposed to stay away from that. Because in the future, it could be self-serving to the government. Oh, what? Wait a minute. What just happened?
Don't require me to go through a full trial. And so the idea is that because the system has grown so large and there are so many cases, that it's a relief to the prosecution and the court system not to have a trial in every case. And the benefit to the defendant is that he gets a slightly better deal or is able to plead to a lesser crime.
Over the course of the...
Well, I mean, really, people, any fractions here in Texas is a crime. But everything is done in administrative. We're not even a judicial branch. So even though we're doing all these plea bargains and all that, it's not under the guides of the judicial branch. It's under the guides of the administrative.
19th century. Prosecutors are really taking over most of these cases. It goes from a few percent to the lion's share of cases. And then defense lawyers get hired more and more to counteract that. Well, once you have prosecutors and defense lawyers on both sides, and the Sixth Amendment guarantees you the right to hire a defense lawyer, that's how it's understood. And
remember the key word? Defense lawyer. Defense lawyer, not counsel. The Sixth Amendment does not guarantee you a lawyer. It guarantees you a counsel. Because he's supposed to help you in your legal process, but nobody's supposed to speak for you. They can if it's corporation on corporation. I'm just saying, if you can put the math together, if this is what attorneys are doing, then they're considering us a corporation against the corporation.
18th and 19th centuries. The prosecutors and defense lawyers develop rules of evidence, and they develop procedures and jury instructions, and they argue motions. And so they get more active, and the judge gets more passive or reactive. So the judge isn't pushing the case along as much, and the prosecutor and defense lawyer are slowing it down. Now, that seems like it...
What do they call that? Being lazy. They know it's overwhelming. So what else can you call it? Well, they slow down. They slow down. Judge slows down. He's not pushing it. Everybody's being lazy.
makes it fairer. But once it gets to a certain point of being slow, the prosecutors want to get rid of the cases. They have too many of them. The judges, they have a bunch of civil cases they need to get rid of. And so the prosecutors and the judges and the defense lawyers all get together and find ways to bargain the case away rather than spending now it's days on each case for trial. So from their point of view, it makes sense. They have a faster system and everyone goes home happy and the prosecutor can pursue more cases and the defendant gets a lighter deal, but the prosecution makes sure there's some conviction and sentence. But for the
Except for the average man and woman that does not study contract law and this law, that law, it seems to make sense to them until they go back out in the world and say, hey, I'm having a hard time finding a job. Just saying. The lawyers wait until the last minute, especially court-appointed attorneys, they wait until the last minute. And then they run bounce you. Okay. I just wanted to get it done with. Okay? You don't even have time to sit and think. You don't have time to go in there and read their definition. Right? Not your definition, everyday men and women, but the court's definition of that contract.
Of view of the public doesn't see justice done and the public doesn't trust these plea bargains. But at the end of the day, what the defense lawyer is mostly doing is not making sure there's a speedy and public trial, but bargaining the 95% of cases away before there's a trial.
What happens if the defendant can't afford a legal counsel?
The history of the right to counsel is actually one of the more interesting components of the Sixth Amendment because many of the components have deep roots in the history of England, and so were rights that Englishmen enjoyed for many, many years before they were brought over to the colonies and became part of our Constitution of the United States. The right to counsel is a little bit different in that respect. Criminal defendants in England and in other countries around the time of our founding often did not have a right to counsel of any kind, whether they could pay for it or not. And so this was a bit of an innovation on the part of the framers, recognizing that all the other rights they were identifying to defend yourself in court might not amount to much if you didn't have expert assistance, or at least the right to obtain expert assistance.
Expert assistance, not for assistance.
So you described a lot of
It may shut off any given minute.
changes to how our legal system works over the years. What do you think would have surprised the framers most about how our legal system works today?
I think they would have been shocked that a system that was meant to slow down and check governmental power and protect overreaching and protect the people's role has been so subverted that the people are involved in a few percent of cases. They designed a system it's slower and less efficient by design than the criminal justice system of continental Europe because they were worried about the king and the crown pushing around citizens and abusing their power. They wanted grand juries to authorize every criminal charge. Well, we've largely gotten around that in most cases. They wanted petty juries to ensure that every prosecutor's charge was justified and that the legislature's criminal laws weren't being applied too broadly. And again, prosecutors now have so many threats and tools and sentences that they can make almost everybody give up their jury trial rights. But the framers...
This is a judge saying that, y'all. Not me. Well, I am, but...
also weren't dealing with the volume of cases we're talking about, and they weren't focused primarily on the violent crimes. The federal crimes they were dealing with were seditious libel, criticizing the government, violations of the revenue laws. So it's also fair to point out that they did not expect that these rights were mainly going to be limitations that benefited people in rape and murder cases. And a lot of these protections are mainly designed to make sure that the innocent people get vindicated against unjust charges. And they might be a little bit surprised that almost all the litigation is by people who may be factually guilty.
The next thing that would have surprised the framers a great deal,
I guess we're going to make a small part 3. Sorry, I yapped too much. But come on, clear that up. Check out this YouTube channel, KHANACADEMY. Okay? These are We the People News. Bye, y'all.